I'm delighted to appear at Berkeley Law School for this important conference on the emergent right to repair. This time I'm appearing virtually, but I have been grateful in the past for visiting Berkeley Law School when I was doing work on other topics such as gene patents and clean technology. My name is Matthew Rimmer, and I have really become interested in the right to repair out of a series of different research interests. So I've been doing a lot of work on intellectual property and climate change over the past decade. I've been very interested in intellectual property and sustainable development. I've also been doing a lot of work around intellectual property and 3D printing, in which the right to repair is a kind of an important issue across all those disparate fields. I'm a professor of intellectual property and innovation law at the QT Faculty of Business and Law in Australia, and I will really be telling the story of the Australian fight for the right to repair. As is always the case in Australia, I'd like to acknowledge the Turrbal and the Yugara as the First Nations owners of the lands where QT now stands. And I would also note that there's a kind of an ongoing struggle in Australia and internationally to try to get greater recognition of Indigenous intellectual property. In Australia, the right to repair is a very critical issue for many Indigenous communities in rural and regional Australia. To begin with, I'd like to give you a quick sense of some of the politics in Australia of the debate over the right to repair. Historically, as a British colony, Australia was very much dependent upon supplies of goods from the United Kingdom. So as a result of those difficulties in terms of gaining supplies, there was quite a thriving local culture of repair in colonial Australia. After Australia's independence, Australia became much more dependent upon mass-marketed imports from overseas. When I was a student in the 1990s, the right to repair really started to emerge in relation to debates over the question of spare parts for motor vehicles. But the topic has really kind of come to the fore over the last few years in Australia. And we're kind of grateful that the ACT Attorney General Shane Rattenbury, a member of the Australian Greens, has been a great champion of the right to repair. He has pushed for his fellow territory, state and federal ministers to support an inquiry into the right to repair, but also to try to push some law reform in relation to consumer law, competition policy, questions around intellectual property, as well as kind of taking some larger action in relation to sustainable development and climate action. And this has been a really important contribution because Australia does not necessarily have the same well-organised civil society groups working on the right to repair like in the United States or in the European Union. Surprisingly for Australia, there has been some very kind of important kind of consensus between the major parties on this issue. So the Australian Labor Party, who are the federal main opposition party, have been interested in the right to repair, particularly in the context of motor vehicles and the need for independent repairers to kind of gain access to repair information. So Andrew Leigh has been kind of quite vocal in that regard. Of the ruling coalition parties, the National Party in Western Australia have been very keen on there being action in relation to the right to repair to deal with agricultural machinery. So as a result, the Liberal Party, who are part of the kind of conservative coalition at the moment in power in Australia, agreed to a reference to the Productivity Commission to investigate the topic of the right to repair. Given that an election at a federal level is imminent in Australia, it will really be left to the next parliament to determine what, if anything, happens in terms of some of the recommendations that have been flowing from the Productivity Commission. So I just want to give a quick overview of the Productivity Commission inquiry and then look at some of the elements of the inquiry dealing with intellectual property, consumer law and competition policy, e-waste and product stewardship. And I'll wrap up saying a little bit about innovation law and policy, comparative developments and international law. The Productivity Commission is a kind of an independent body in Australia that carries out empirical economic research to better inform law reform in Australia. It's kind of played a really kind of critical role as a catalyst for law reform in lots of various areas. And I have to say, the Productivity Commission inquiry in relation to the right to repair has been one of the best processes of law reform that I've been involved in Australia over the past couple of decades. The inquiry was very well run by the commissioners Paul Lindwall and Julie Abrahamson. They had a very good process in which they kind of went through an issues paper, a discussion paper, and a final report. The final report is open access. It is a good 384 pages long. I would highly recommend that you download it and have a look and read some of its insights. The inquiry was kind of informed by consultations, submissions, and hearings. Even though there were a lot of COVID-related interruptions in Australia at the time, nonetheless, I think the Productivity Commission did a very good job in terms of canvassing the community about the issue. In terms of a kind of a broad brush approach to the key recommendations, the Productivity Commission has called for an enhancement of consumer rights, a promotion of competition, an enablement of access to repair supplies, and improvement of product information, e-waste management. In my kind of submissions to the inquiry, I was kind of pushing for some slightly bolder recommendations, but I'll kind of talk about that as we kind of go through the recommendations one by one. In terms of intellectual property and sustainable development, the Productivity Commission were very focused upon copyright law. And in terms of their kind of key recommendations, they recommended that there should be law reform in relation to copyright law. They recommended that Australia should amend the Copyright Act to include an exception that allows for the reproduction sharing of repair information. In the medium to long term, it recommended that the Australian government should pursue a more flexible copyright exception regime, including a principle-based fair use exception. They called for amendments to the technological protection measures regime, and they also called for prohibitions on contracting out of copyright exceptions. I guess those recommendations kind of partly reflect the engagement of many copyright-based organisations in the Australian debate. And, you know, some of the legal professional bodies in particular seem to influence the approach of the Productivity Commission in pushing for copyright law reform. I would note, though, that really the right to repair is a combination problem that cuts across a wide array of different forms of intellectual property. And I kind of argue that it would have been better for the Productivity Commission to make similar reforms across the different disciplines of intellectual property. In relation to designs law, there is an explicit spare parts exception under Australian law, and that has been recently tested in a case involving customising cars, which is kind of a great Australian hobby. And that spare parts defence was successfully used in that case. However, the provision is really quite convoluted and complex and is increasingly looking a little bit outdated. We would benefit from a more general defence in relation to designs law dealing with the right to repair. In respect of trademark law, the Productivity Commission did not make any kind of recommendations for law reform. In my submission, I kind of pointed out that Apple had kind of taken action against an independent repairer in Norway, and that there was a similar risk of something similar happening in Australia, but they didn't make recommendations in that particular field. In respect of patent law, the High Court of Australia has handed down an important decision recently dealing with patent exhaustion in the context of refurbishment of printer cartridges. So strictly speaking, not exactly a repair case, given that was dealing with refurbishment rather than repair. The Productivity Commission were of the view that the ruling on patent exhaustion had a more general application in relation to the repair of patent inventions. I would argue that the High Court decision does not necessarily lay down very bright lines about what sorts of repairs are permissible and what sorts of repairs are not. So I think that area would also benefit from some sort of explicit defence. In relation to trade secrets law, there was a little bit of discussion about the impact of trade secrets upon repair, but unfortunately there wasn't really much in the way of law reform recommendations. I think that's quite a big issue, particularly given that Australia has expanded its regime for trade secrets. There's also a bit of discussion around data and information as well. So there's a special Treasury scheme in Australia about repair information for motor vehicles. There was a bit of discussion about whether or not there should be similar requirements and obligations in relation to other sectors and fields. So that was the key set of recommendations in relation to intellectual property. In respect of consumer law and competition policy, the Productivity Commission did acknowledge that the Australian Competition and Consumer Commission had taken some action in the past, particularly under consumer law, against companies. In particular, there had been action taken against Apple. In their report, they expressed concern that consumers sometimes lack the ability to exercise their existing rights to obtain remedies for defective products through consumer guarantees. So the Productivity Commission called for a super complaints process, enhanced dispute resolution powers, enhanced regulator powers to enforce guarantees. They also wanted to require software updates for a reasonable period. There was also some discussion of competition in repair markets. They found in the Productivity Commission report that there was no evidence of a systematic competition problem across all repair markets. They did identify, though, that there were some markets that seemed to have some problematic issues around competition. They noted that the limits on repair suppliers for agricultural machinery were causing harm. They were uncertain about the extent of harm in mobile phone and tablet repair markets. They also noted that there were some issues in relation to watch repair supplies. I had a bit of a debate with the Productivity Commission about medical device regulations, particularly given the context of the COVID crisis. The Productivity Commission said that there really needed to be a further inquiry to deal with such matters. The Productivity Commission also kind of suggested that the Australian Competition and Consumer Commission could also kind of take further action in relation to enforcement. It's notable in the United States that the trust-busting hipster Lena Khan has been appointed to the Federal Trade Commission as chair, and she has promised the Biden administration that she will use the full suite of her powers and regulations to take action in relation to the right to repair. That might encourage some further action being taken in Australia as well. Just note in relation to EWaste and product stewardship, there are an array of fab labs, repair cafes, and social enterprises that raise concerns about product obsolescence and the explosion of e-waste. And there were some international organisations as well who also joined in that debate, like the redoubtable iFixit. The Productivity Commission, though, only grudgingly conceded that e-waste was a small but growing waste stream. They argued that the evidence on premature obsolescence was mixed. They were of the view that interventionist responses to premature obsolescence were not needed, and that there was a need to provide better consumer information and develop and introduce a product labelling scheme like France. In some ways, I think that the Productivity Commission perhaps could have had some stronger recommendations in relation to some of the environmental dimensions of the right to repair. I think another kind of really important issue from an Australian context is boosting innovation in respect of sustainable production and consumption. Some jurisdictions like New South Wales have set up circular economy innovation networks. There's been very creative researchers like Professor Veena Sarawala, who has been doing really interesting work on the use of waste materials. Australia, though, seems to be lagging behind some other jurisdictions when it comes to sustainable innovation. So really, we need to boost the circular economy in Australia. The Productivity Commission report also draws upon developments in the United States and Canada, which you'll be hearing about at this conference, as well as in the United Kingdom, the European Union, and South Africa as well. And hopefully that will help encourage Australian legislators to kind of take action in relation to the right to repair. But really, I think what this conference is showing that there's a kind of a larger international movement for there to be recognition of the right to repair. It's notable that the United Nations Development Programme has been setting up a network of accelerator labs to help realise some of the Sustainable Development Goals, including Sustainable Development Goal number 12, relating to responsible consumption and production. I think it's kind of critically important that we try to push for a greater international recognition of the right to repair in that context. Just to wrap up, I would note that even in a galaxy far, far away, the right to repair is a critically important issue. In the Star Wars trilogies, it's a coalition of hackers, scavengers, and junkers who take down the evil empire in the First Order. I think in relation to the debate over the right to repair, we need a similar broad-based alliance to make the right to repair a reality. Thank you very much for your time and attention. It's been a pleasure to join this event. Thank you very much.